Good evening and welcome to Lawyers on the Line. I'm Jim Peterson, a partner at the Falsani Balmer Peterson and soon to be Ann Balmer law firm, and this evening's moderator. Tonight we're talking about workers' compensation. When an employee gets injured on the job, that employee has the right to a number of benefits under the law. Handling medical bills and wage loss, changing doctors, getting back to work, and simply navigating the system can all be very complicated. I'm pleased to welcome tonight's panel, Sean Quinn of the Falsani Balmer, so far Quinn firm, Kathy Bray, in-house counsel for SFM, and our partner Stephanie Balmer of the Falsani Balmer firm. We're ready for your workers' compensation questions. Call locally at 218-788-2844, or if that's long distance for you, call toll-free at 1-877-307-8762. Now, before we get to our first question, the confusion, Sean Quinn, our longtime partner, has been appointed by Governor Dayton to the Workers' Compensation Court of Appeals.
Yay.
Right?
Yay.
He has 2 weeks left. So the first question is, what exactly are you going to do on this new job?
The Work Comp Court of Appeals is a group of judges that review workers' comp trial judges' decisions that are on appeal. So there's 5 judges there. Generally, a group of 3 judges reviews every case, sometimes all 5. So I'll be reading appeals and writing decisions.
All right. Do you have to move?
Probably. Court's in St. Paul.
All right. Yeah. Well, we'll get back to you.
All right.
First question, Kathy. How come the insurance company doctor decides everything about the case? In other words, why does the workers' compensation insurance company or employer believe what their doctor says rather than the treating doctors or the employee's own doctors?
Well, with the way you phrased it, it's made to sound that the insurance company doctor, quote unquote, determines everything in the case. And what this is referring to is the fact that under the law, the employer and insurer have the right to obtain an examination of their choosing with a doctor of their choosing. If they have a question of maybe the treatment suggested just doesn't seem to be adding up, maybe they want a second opinion, and so they have that right under the law. Sometimes you go to hearing with it and the judge may adopt that doctor over the treating doctor's opinions. On the other hand, there are plenty of times where the treating doctor's opinions do prevail, so it really is just another piece of the puzzle in determining compensation and benefits.
Well, Stephanie, when this happens, when there's a doctor who's the employee's treating doctor, when there's a doctor who sees the person for the insurer, how does that affect a return to work issue? In other words, how does the employer and the employee decide what doctor's opinions to follow?
Sure. Well, in a return to work situation where the employee has been off work, probably because of the work injury, at some point the treating doctor is meant to provide the treatment to the employee to rehab that individual, and then the treating doctor usually provides restrictions that ideally would allow the employee to return to the date of injury employer. Some of the dispute can arise as far as whether the restrictions provided by the treating doctor square with the job description of the date of injury job. In other words, if the injured worker is concerned about whether the lifting, sitting, standing, etc. restrictions will be honored in the return to duty, that's where some of the stress can come about. And there's a lot of different solutions to that. One is for the injured worker to take that issue back to the doctor and say, you know, you released me with these restrictions and I'm trying to do my job, but technically it's within the restrictions, but it's hard because of this, and because the treating doctor is ostensibly always going to be the arbiter of what the restrictions are, unless there's another doctor involved, like Kathy was talking about. If the insurance company's doctor or independent medical examiner has different restrictions, then the employer-insurer may be inclined to adopt that doctor's restrictions or lack of restrictions, and then you may have to file a claim.
And it also causes all kinds of problems where the employer will adopt those insurance company doctor restrictions and say, come to work with these restrictions or we're not going to have a job for you anymore.
Right.
And
Right, so
until
what
a
happens
judge
then?
ultimately, well, if a judge ultimately makes a decision in a different way, maybe the employee gets their job back, but in the meantime, the employee might lose their job or they might have to try to work with those other restrictions. Some employees are afraid to take that risk because there's always a fear of re-injury. Employees always suffer that fear of re-hurting themselves and going all the way back to square one. So they don't want to do that, but they don't want to lose their job. It can be very frustrating for the injured worker in that circumstance, and there's no real right answer.
But,
Well,
but on the other hand, sometimes as an attorney representing employers and insurers in the system, there are employees who do not like the work they have available to work within restrictions. So for example, you've got a 20-pound lifting restriction and your regular job requires 50. Maybe that means you're going to be doing some paperwork or less rigorous work in order to stay within restrictions, and the employee doesn't like it, and so they ask the doctor to take them off work because they can't do their regular job. And that's sometimes where the tension comes in, because the employer is trying to provide work and the employee doesn't want to do the work that's available.
What about this? We get this question all the time. Stephanie, we're back to you because you're going to love this question. You've got restrictions, working light duty, everything's fine. Suddenly, the insurance company doctor opinion comes in and the employer says, come back Monday and do your regular job, no restrictions, or you're done.
Yeah, so in that situation, the employer and insurer have the report from the doctor that they had hired to do the examination, and that doctor either says, there's nothing wrong with you, you're fine, or maybe there's something wrong with you, but it's nothing to do with this work injury, which then removes the employer's obligation to honor, in a lot of circumstances, to honor those restrictions. That is a tough question. What Sean said is the first response I'll have. As far as re-injury, we usually tell our clients, don't do anything that's going to hurt yourself. I mean, if you go back to work under this theory that you have no restrictions, and you're going to hurt yourself, don't do it. And that's the first piece of advice. But what I also tell my clients is, can you give it a try? Can you try it? And then if you do end up experiencing increased symptoms or you have some other very adverse consequence, go back to your doctor and document it or do something. And ultimately, if it ends up being that the employer says you either do this job with no restrictions or not, then the injured worker can ask for what are called temporary total benefits. The employer insurer would likely deny those, and you'd have to file a claim petition to recover those.
Right, and the fact of the matter is, as workers' comp lawyers, we interact with employment law, but the workers' comp law, Kathy, doesn't say anything about your job security,
That's
right?
True. That's true. There are various laws that talk about job security, Family Medical Leave Act, things like that and actually interact with the employment relationship. And while workers' comp has to do with injuries that occur within employment, it doesn't talk about that employment relationship. So there are no true job protection provisions under the Work Comp Act. There are anti-retaliation provisions, there's anti-discrimination provisions, but there's no true protection in terms of saying to an employer, you have to keep that job open while someone is off on workers' comp.
We've got some questions coming in already, thank you. This one, Sean, I'll get to you. We have all these disputes, that's why people come to see lawyers, I suppose. Right. And on the one hand, you've got an injured worker. On the other hand, often you've got an insurance adjuster. The question is, why don't they make the insurance company adjusters testify at the hearing?
Well, typically the adjusters aren't going to testify because what they have to say isn't relevant to the issues at hand. The issues are typically, how did the injury happen? What work restrictions do you have? What's the nature of your injury? And so forth. Cooperation with job search, a number of things. There's nothing the adjuster can do to add to that. Every once in a while, there's an issue where an adjuster's testimony actually might be relevant. Every once in a while, we take the position that the insurance company has acted exceedingly wrongful to the injured worker, where a penalty might be appropriate. And there we might call an adjuster to testify and have them cross-examined, or Kathy might call the adjuster to testify, no, I had a reasonable basis to take this action. But what adjusters have to say is generally not relevant because they don't have any direct knowledge of anything that has to do with the injury or the medical care.
Kathy, that kind of brings up an issue that I've always wondered about. As a lawyer who represents the defense, basically, you're representing both the employer and the insurer. Okay?
That's correct.
What happens when there's a conflict, when they don't have the same interests?
Well, if there's a true conflict, and that could be a whole other show in terms of talking about actual legal conflicts of interest, but if there is a claim where the employer and the insurer's interests are truly adverse to each other, the insurance company will retain separate counsel for the employer, or the employer may retain separate counsel on their own. Typically, it's in certain cases where maybe the premium of the employer may be adversely affected, or there comes some information to light that there's some question maybe of some liabilities outside of the work comp claim. So there's the rare case where there's a true conflict, and then you'd see separate counsel retained for both. But otherwise, there's a unique situation where because of the nature of the insurance policy, insuring an employer, they have dual interests typically that don't require separate representation within the work comp system.
Well, what about, an injured worker's off getting workers' comp, and the insurer who's paying says to the employer, hey, get this person back to work. We're tired of paying them. And the employer says, we don't want them there. We need people who are doing, all the welding, not half of it.
Right.
What do you do then?
Well, that's really almost more of a work comp exposure issue as opposed to a conflict of interest. You've got an insurer who says you'd really decrease your exposure on this claim if you can bring them back to work. And that's always some of the best advice. Is it's good for the employee, it's good for the exposure of the claim to get someone back to work. The longer someone's off work, the less likely it is they're going to come back to work. And it's just mental health-wise not good to be off work for a long time if you can keep working. But on the other hand, if the employer says, I don't have jobs with a 10-pound lifting restriction, the insurer can't say there's a conflict of interest necessarily, but they can say to the employer, this is going to drive the cost of the claim up, which may drive your experience modification or modifier and your premiums up too. So the things that are affected are not what's considered a conflict of interest.
What happens, Stephanie, we're kind of on the same topic here, when the employee and his or her own doctors don't agree on return to work issues?
Yeah, that happens. A lot of times what can drive someone into a lawyer's office is problems getting support from their medical providers. And so there are a lot of different reasons why a medical provider might not see eye to eye with their patient. That's a totally different relationship that I try really hard not to interfere in. But it may be that the doctor doesn't do work comp, which I'm seeing more and more. In that situation, a doctor might send the employee to an occupational medicine specialist. And, doctors are people like anybody else, and they have their opinions and their biases and their strengths and their weaknesses. So if someone comes to me and we have a big problem between what the employee thinks he or she can do and what the doctor thinks that person can do, I explain to them, that your claim probably depends on getting some sort of alignment, because usually it's that the doctor doesn't want to write anything down, doesn't want to put restrictions on them, or doesn't want to refer them for any additional treatment, and say, well, I can't make your doctor do something. You can suggest that someone see someone else, but again, I really don't like to interfere with the treatment. Once in a while, if we have a client who just cannot get any help from their providers, we might send someone to an independent medical examiner too. That's not ideal because seeing someone on a one-time basis for the purpose of an opinion, that I'd rather have a doctor who knows you and has been very thorough, but it's not ideal. So,
Sean, a question from a viewer: why can't you collect for pain and suffering in workers' comp?
Well, the simple answer is because the statute doesn't allow for it. Workers' compensation is it's a statutory scheme. It was a product of the Industrial Revolution from over 100 years ago, and it's a compromise. And the compromise is that there are certain benefits that the employee cannot have. Pain and suffering is one of them. Benefits to this employee's spouse or children is another. In exchange for that, the employee does not have to prove negligence on the part of a coworker, the employer. The employer can't use the employee's own negligence as a defense either. It's a no-fault system, so it's just a statutory scheme. It's the law.
Can't they say that you were negligent by falling on the stairs yourself rather than?
Well, the employer can say whatever they want, but they can't deny benefits because of that.
Really?
They might be able to. They might be able to do it for if you fall on the stairs. They might argue that that isn't a work injury, but that's a separate thing.
That's not a negligence issue, though. That's just a question of whether there was an increased risk of employment that led to the work injury.
Right.
You are the moderator, not a panelist.
Kathy, we've got a number of questions about reporting an injury. First of all, how important is it to report an injury? And what if you don't and the injury turns out to be more than you thought at first?
Well, it's extremely important to report an injury and to report an injury timely. And we tell that to employers, too, that it's very important that you encourage your employees to report injuries. And the problem with the idea of just self-monitoring and having an employee decide whether it's worth reporting or not is that sometimes you miss an opportunity to manage it early on with appropriate medical treatment, that it could have taken that small injury and prevented it from becoming a big injury. And that's why there's time limits that may bar compensation if you don't timely report it. So the employee should have an interest in reporting an injury as well. It allows them to get access to proper care at the appropriate time frames, and also make sure that they're not doing something at the workplace that goes beyond, perhaps they have restrictions, for example, that they work within restrictions then and don't do something that further injures themselves.
Stephanie, what about the case, and this happens, maybe it's a kind of a rogue employer thing where employee gets hurt, tells the boss, hey, I got hurt on the job, and the boss says, too bad, I'm not going to file anything. I'm just not going to.
We had a call this week about that, actually. Someone had gotten hurt on the job, and getting hurt on the job is not necessarily, I broke my arm this day at this time doing this. It can be a condition that develops over time as a result of certain activities, and so it isn't always crystal clear as far as when did I get this injury, and when do I need medical care. And so what happened here is, my understanding is the employer, without having that crystal clear when exactly did this happen, did not want to fill out an incident report or a first report of injury, and so refused to do so. And our advice was, my advice was to put something in writing and get it to the employer in some way to prove that they got it, either by email or by fax or certified mail or something, to ideally remove any dispute over whether it was injured or whether it was reported. And then second, to contact the Department of Labor and Industry, because they have an interest in making sure workplace injuries are reported and that employers are working with their employees for all the reasons Kathy just described.
What if in that situation the employer, say, is trying to avoid lost time injuries, Sean, and says, I don't want to report an injury, I'll just take care of you. We'll give you sick time or whatever. We'll take care of your medical. Is that allowable?
Well, the most important thing, as Kathy already said, is the employee has to report the injury. Once the employee's done that, the employee is protected by the work comp system. Now, the employer-insurer, they have an obligation, or the employer, has an obligation to work with their insurer and cooperate with their insurer. So when the employer just says, I'll just pay for that bill myself, I'll pay for that medical bill, or I'll give you a day off sick pay, they may be putting their own coverage at risk. And that does potentially create this conflict that Kathy says doesn't happen too often, because that doesn't happen too often, that kind of thing. But with that said, there is a provision in the law that allows the employer to make some payments on, isn't there? on wage loss benefits?
There used to be.
Okay, I thought that still was
Yeah,
there.
in fact, a memo relatively recently,
Okay.
in the last couple of years, came out saying wage continuation is really no longer
Okay,
encouraged.
so that's not even out there anymore. So, but generally, the employer puts their coverage at risk when they don't cooperate with their own insurance company, just like anyone who has insurance.
And that's one of the reasons why I don't like those signs or those,
Yeah.
I saw someone the other day.
400 days without
Yeah,
work
yeah.
injury.
Someone was wearing a jacket for a local employer about, how many days. And I get the idea, we all want safe workplaces, but the problem with that is that it creates this environment where people are less inclined to report the injury.
Right. Yeah. Well, we all would have got donuts on Friday, but Billy fell down, so no
Right.
one gets
Yeah,
donuts.
thanks a lot,
Yeah,
Billy.
Yeah.
Yeah.
Yeah, well, and meanwhile, there's 4 people sitting in the lunchroom doing absolutely nothing, but they're not losing time because
Yeah.
they're.
Yeah, that's true.
Yeah.
But I think it is important that there is a culture of encouraging safety and keeping each other safe.
Yeah.
So
Oh,
I think
true.
Yep.
having these safety incentive programs on some level is important to have in a workplace because everyone should be helping each other stay safe. So if you see someone who's working without safety equipment they should be using, you should feel comfortable calling out to say, "Hey, Steph,
Yep.
hard hat. Let's keep this an injury-free workplace kind
Yep.
of thing." So I think there's
I think it's
certain
a line
programs
to
that can
walk.
incentive it.
Yeah.
Well, Wisconsin, for example, has a statute that has enhanced or decreased compensation based on safety. If an employer violates a safety rule, the employee can actually get more, money, and if the employee violates a safety rule, they get less. So it's kind of built in. It's very seldom invoked, though.
Yeah.
I don't know. Have
And
you ever seen? You ever seen anybody invoke that ever?
No, but I have a case right now where that's at issue. Both the employee and the employer are pointing the finger at each other as far as safety goes. So,
Nice.
Next year.
yeah,
Yeah,
right.
We'll talk about it
Same,
next year.
the same rule applies if you're intoxicated at the time of the injury. You get slightly less money if you.
Slightly.
All right.
Huh.
Let's, John, new topic. Doctor shopping. Well, doctor choices. Who gets to choose the doctor after a work injury?
The employee gets to choose the doctor. The employee always has the right to choose their own doctor. Once that selection is made, however, you've had a visit or two with this doctor for your work injury, and then you say, I don't care for this doctor anymore. Now you're not necessarily allowed to change doctors without insurance company approval. What is more common is you start with your family doc, and then your family doc says, I'm going to send you an orthopedic or a neurologist or an occupational medicine doctor. That's not doctor shopping and that's not doctor switching. That's just getting referred to a specialist. But the employee has the absolute right to select a doctor.
Yeah, and sometimes it gets real nitpicky. If your doctor's on vacation and you see whoever's on call,
Right.
and then are you picking a new doctor?
Yeah, and that happens when you have an adjuster who, for some reason, doesn't like the employee or thinks something's fishy, and they start picking very detailed things. But normally that gets worked out pretty easily.
Kathy, a good question for you. This is from a QRC, which is
A qualified rehabilitation consultant.
who has this question. What data practice restrictions are required by an employer
Jeez.
about an injured worker when it comes to talking about or showing info to other employees?
What data practices are applicable?
I
Is
read
this
it.
a trick question?
I read it word for word.
Yeah.
Sometimes I make stuff up, but I actually read that one.
If I'm understanding the question, I'm reading it as what restrictions are there on the injured worker sharing their information with other coworkers?
No, I think they mean the employer.
Probably the employer sharing, hey, we should tell you about Billy's, tell everyone else
Oh,
about
okay.
Billy's restrictions, that
I
kind of thing.
misheard it. I mean, in terms of what the employer can share with other coworkers, it's essentially treated. I always say treat it like medical information. Assume that anything related to the work comp system is a medical related data, and it should be treated with that level of confidentiality. It should be maintained in a separate file. It should not be part of the regular personnel file. And in terms of even restrictions, how long they're going to be off, even with well-intentioned inquiries where they say, hey, how's Billy doing after that surgery? Everyone, quote, knows Billy's out for surgery. It's still something the employer is not at liberty to share, and they should always keep personnel information close to the vest and only sharing it with supervisors or safety and health people who need to know perhaps if there's an increased risk or a medication issue they need to know about. But otherwise, the answer has to be, I wish I could share more with you, but as you know, I can't share personnel information with you. If Billy wants to share that, on the other hand, he can share whatever he wants with his coworkers. But the employer, even if they're doing it for the right reasons and just to keep everyone in the loop because everyone's really interested in how he's doing, you can't share that information on a regular basis.
Well, what if it's not a friendly thing though? What if, you know, the employer calls you as the lawyer and says, Kathy, everybody is complaining because I had to put Frank on restrictions and they're all doing his work now.
Right.
And what do I tell them?
Well, I think that's one of those things where they come up and say, I'm tired of Frank only doing half his job, for example.
Right.
The supervisor needs to be well schooled and trained in terms of how you handle, basically in a nice way saying, you need to worry about yourself, and we're all pulling together as a team. Hopefully this is temporary without giving any details, and move on from there. But if they get into what's going on with Frank, how long is this going to go on, it really has to be a relatively discreet, narrow response to say, let me know if you're having problems with it, but otherwise let us worry about Frank and you worry about you.
Yeah. All right. Stephanie, question. I work for myself. Do I have to have workers' compensation insurance?
No.
Okay.
But
Sean.
you might want to consider it.
Yeah, you should.
And this sometimes happens when you've got, say, a general contractor and a subcontractor and a sub who maybe is, the siding guy, and that's one question. But then the siding guy gets his nephew to help out. So at what point do you have to have coverage?
You go, because you advise people on this all the time, don't you? Well, okay, so an independent contractor is not an employee.
That's such a multi-layered question,
it is,
though.
and that's the way I'm going to take it. So an independent contractor is not treated as an employee under the Workers' Comp Act. And so a contractor does not have to have work comp coverage for subcontractors, independent contractors, things like that.
But the independent contractor could have insurance for himself and for his employees.
If he or she
Yeah,
chooses
if
to,
yeah.
and for their employees, they would, yes.
But you don't have to cover your direct immediate family.
See, there was a twist.
Yeah, a little twist. The nephew.
All right.
Is that immediate family?
The nephew's
Just
probably
kidding,
not.
Just kidding.
John, what happens, and this is a follow-up to what we just said, what happens if I'm injured and my employer doesn't have any workers' compensation insurance?
Well, in Minnesota, we recognize that can potentially happen. Some employers just don't buy it. And so we have a system in Minnesota where the state steps in with a state agency called the Special Compensation Fund, and they act as if they were the insurance company. And they provide the same workers' compensation benefits that any other insurance company would provide. That agency then separately, usually not right away and usually at the end of the litigation, or the end of the injury, commences a lawsuit against the employer for all of the benefits that they paid and a whole bunch of penalties and a bunch of other things that you don't want to. That's why you buy work comp insurance. It's a lot more expensive if you don't, because then you end up paying the whole claim yourself plus a lot more penalties.
Right, but hopefully the employee has already been compensated.
The employee gets compensated by the state regardless. Yeah.
This is a question that was called in. Kathy, I'm going to read it word for word again. How are workers' compensation laws decided?
Oh.
Much like sausage is made.
Well, it is a creature of statute. So it is the legislative body who creates the primary statute that governs the workers' compensation system, the overriding umbrella. There are rules and regulations under that, though, that may be more departmental in terms of administrative agency in nature, and they do also affect different components of the work comp law. For example, we have medical fee schedules. We have certain kinds of treatment parameters that decide how much is too much with certain kinds of treatment, or at what certain stages of a claim is it appropriate to get certain kinds of maybe injections or imaging studies. So there's different layers with that. And then there is the case law in terms of judges, the Court of Appeals, administrative judges, also further defining and interpreting the law that's applied that affects future benefits and how they're determined.
Yeah, and then in Minnesota, 25, 30 years ago, a statute was passed that says before the legislature will generally consider any change in the work comp law, they're going to run it through something called the Workers' Compensation Advisory Council. And that's made up of 3 members of labor and 3 members of business. And no lawyers are allowed. And they meet periodically and decide what laws should and shouldn't be passed or changed. And since there was a major change in 1995 that wasn't run through that system, since then every workers' comp law has been run through the WCAC before the legislature even looks at it.
And, you know, we picture a darkened room with candlelight and people with hoods on and stuff,
Yeah.
but it is an open process. It's open to the public.
It's open to the public, but only they really limit who's allowed to speak during these things. And generally, because workers' comp can be so political, it takes a lot of political motivation for anything to get through that system, any substantive change in the law.
Yeah, and again, for those of us who practice in Wisconsin, they have something called the Labor and Industry Review Commission, which is just blatantly political. And every time there's a new governor, the law literally, in some respects, changes 180 degrees.
Yep.
And there's like no good precedent at all. Okay, question, is it Stephanie's turn?
Sure.
Got hurt at a long-time job, paid benefits, eventually got a different job at a different employer, hurt again, same body part. How do you decide who pays what?
I would say report the injury, okay, first of all. And some employers give a little pushback and say, well, didn't you have this problem? Yeah, just report it. Because the insurance companies will probably duke it out. At some point, your doctor may be consulted as far as, do you think this, was the original injury or a new injury or both? And it's really a medical decision that'll be based on, hopefully, objective findings by the medical providers, symptoms. Maybe you got back to work 100% the first time, no restrictions, no treatment for 10 years, and then you re-injured it, and all of a sudden you needed surgery. There's a lot of different facts that could affect how that plays out, but it's a medical decision, really. So. And
a lot of insurance companies will step in and whether it's the first insurer or the second one, say, we know we're not sure which one it is, but we will take the ball and we will pay this claim as if it's our injury. And once it's over, we'll have litigation to decide whether the other insurance company should pay us back in whole or in part.
And that's a lot of what I know Sean and you and I deal with. I have an injury where my guy just needed a medical test. Didn't cost a lot of money, but because there were 4 different dates of injury involved, 4 different insurance companies, 4 different lawyers, so a 4-hour deposition for a $2,000 test. After all of this took place, then I got an email and said, yeah, we'll pay for the test, and then we'll duke it out as far as who has to pay for it. But it's the insurance companies who are going to fight over that. The idea is to get the treatment or to get the benefits and so forth.
So who pays for your time in that situation?
I haven't gotten that far, but it will be the insurance companies. When you have to hire a lawyer or hire a lawyer to get medical care authorized or paid for. And as long as you are successful in that, either by way of settlement or you take it to hearing and win it, then your lawyer petitions the insurer, or in this case insurers, to pay for your fee. And so, that's something not a lot of people understand, because if you took a percentage out of the medical bill or treatment, then the medical bill wouldn't be paid. So,
but that's only in the case of a medical dispute only. When there's
medical only or rehab only.
Right. When there's a case where there's wage loss benefits, then the attorney fee will come out, at least in part, out of the ongoing wage loss benefits.
Or
of
permanency.
Out of a certain percentage.
Yep.
And then there may or may not be partial reimbursement of those fees.
Right.
But otherwise, only in cases of, like you said, with a medical benefit or a rehab case will there be an hourly fee in terms of classic someone's paying a bill?
Workers' comp lawyer fees for the petitioners are extremely complicated.
Right.
Our retainer agreements, well, mine and Sean's anyhow, are very long because it's so statutory, and we do attach a copy of the statute, but yeah, it's complicated.
Sean, in a situation where there's either a dispute between two different workers' comp companies, or maybe just one which is denying it, how does health insurance come into play?
Well, unfortunately, some health insurers don't follow the law necessarily either, but one of the provisions of the work comp statute actually says when a workers' compensation claim is made and medical care is needed and the workers' compensation insurer refuses to pay it, they're denying the claim. This is not a work injury. Then the health insurer must pay the bill. And so it's, there's an obligation on the medical provider too to bill the proper health insurer, Blue Cross or Medica or whoever it might be. But they must pay the bill, and then they can intervene, that is join the workers' comp litigation to get paid back. Hey, we're Blue Cross, we shouldn't be paying this bill, but we paid it and we want our money back. And when the case is over, if the employee is successful, then the medical insurer gets paid back too. And the whole purpose, of course, is to make sure that the employee gets the care and there's no delay in the care. Some medical providers simply won't bill a non-work comp insurer. Occasionally, a non-work comp insurer won't pay the bill, saying this is workers' comp and they need a written denial. That makes sense, but even if they have a written denial, they won't pay it. So sometimes it can, in practice it works, and in practicality it doesn't. So, or in theory it works. I'm sure.
It gets complicated because of the different reimbursement rates. And
Right.
Right, they'd rather be paid by workers' comp.
Right.
Than
A
most
medical
private
doctor doesn't want to
insurance.
get paid by medical assistance, which pays 30 cents on the dollar,
Yeah.
when workers' comp pays 85 cents on the dollar.
Right.
So,
Well, and the other problem is work comp litigation can drag on for months and months. If the medical provider wants to hold out to get this higher payment, they have 6 months to bill. And so if they miss that window to bill the private insurer, then the private insurer may not pay it at all, and they try to push it back on the employee. But yeah, it's...
Kathy, this is another question about reporting the injury. The question is, what happens if you want to report an injury, but that might result in you being fired because of, I guess, bad feelings? Is there a way to report it confidentially so that your immediate employer and your coworkers don't even know you've done that?
No, there's no way to report an injury without the employer knowing about it. And under the law, there is this anti-retaliation provision. You can't retaliate against someone for filing a work comp claim. But just because you have a work comp claim or work injury doesn't mean you can't be fired for poor performance. So if you feel like your job's already on the line and then you're hurt, but you're afraid of losing your job because you're going to be removed from work due to restrictions, it might be a performance issue too. And so there should not be a firing due to the work comp injury, but there may be repercussions because of other things related to the job, and the employee doesn't get to pick and choose when they report an injury or not, and that's why there are those notice provisions. So they can't decide 6 months later, oh, I guess I'm going to lose my job anyway, so I'll report the injury now.
Okay, do you agree with that, Stephanie? I mean, what happens if...
Someone's looking skeptical.
Yeah, well, sometimes, we've seen someone get fired, not, on the face of reporting the injury, but because they were so sloppy in doing the job, that's what caused the injury. And it can be kind of a circular thing. And
Yeah, and it frequently turns into a he said, she said. I mean, the employer will say, no, I let them go because of X. And the employee says, but I know, he said this or she said that, or I heard from so-and-so. Well, that can end up being a subject for a hearing, and it's a fact dispute, and a judge will have to decide it. There won't be any immediate remedy, unfortunately.
Well, let's say they were hurt in somewhere where they damaged company equipment and they were operating the equipment unsafely. They happen to be damaged or injured at the same time. They might be fired or written up or disciplined because of not following proper company protocols or proper safety procedures, and that's completely appropriate to do. Treating the performance separate from the work injury. They also might still be entitled to work comp, may or may not, depending on whether they committed a prohibited act or something. But the performance and work comp issues should be kept separate in terms of how the employment relationship is dealt with.
I remember a case years ago. This might have been when you were with your old firm, one of the mines. The injury happened when the guy rolled a production truck, like go down a hill.
That was my case.
It does happen sometimes where there are
There's some damage
major,
there.
there are major
He got
injuries,
fired,
or
or he had a work comp claim. 'Cause
right,
He got hurt.
or maybe they've hurt another employee as a result of an accident or something, and they might both be entitled to benefits due to injuries. Someone might get fired in the context of that happening, and that's a totally different issue.
Sean, what if your doctor says something to you at an appointment, but it doesn't show up in the documented medical records, and now there's a dispute over what was said at the appointment?
That's like asking, what if the sun rose today? I mean, doctors having incomplete and inaccurate notes, sadly, is almost the norm. Doctors write treatment notes for themselves for the purposes of remembering the next time that they see this client, this patient, what the care was and where the care is going to go next, not to document every single word they said or every detail, because litigation will ensue. Ultimately, it's going to come down to, does the judge believe the injured worker when the injured worker says, but I told the doctor this even though he didn't write it down, or the doctor told me this even though the doctor didn't write it down. And that's just the sad reality. I mean, that's the way I see it.
Well, and one of the big problems has been with the advent of electronic record keeping. And this, I know, makes a lot of people's lives easier, but what I'm seeing in medical records is it makes it easier for the already overworked medical providers to cut and paste and to, I know my mother's medical records still have her working as a legal secretary, which she hasn't done in 20 plus years. So, you never
they just hit
history,
the same
no
button.
change, and also, in the sections of the record that talk about, what that provider is observing, it will frequently be normal, within normal limits, fine. But then there's all this crazy medical care recommended. Why would the provider recommend all of this testing and treatment if, in fact, everything was, and so it's something, again, it's hard to interfere with, and it's frequently outside of the patient's control.
Kathy, here's a question. How do you determine the permanent disability rating, and how is that communicated? How does an injured worker find out what the rating is or try to obtain a rating when there's been, a permanent injury from work?
Well, part of the workers' compensation system in Minnesota has what's called permanent partial disability benefits, and there's this sub-schedule of different body parts having different assigned percentages of disability. And so, for example, you've got a low back injury, there's a whole litany of percentages of disabilities, or maybe zero, depending on what your findings are. But let's say you have a discectomy, and then later you have a fusion. Maybe the discectomy is worth 9% and another 5% for a fusion, depending on whether you have symptoms going down an arm or a leg and what else is going on. And so it varies, but ultimately the doctor who's treating typically will get to the point that they think you've reached sort of a maximum healing or maximum medical improvement, it's called. And they have a certain form they can fill out, or they may just put it in a medical note. There's no requirement in order to assign a permanency rating that they use a specific form, but there is a form called the healthcare provider report that the insurer often sends to the doctor to fill out. Includes a permanency rating, whether they're at MMI, and then typically that is sent to the employee and said, we're serving you with this MMI report, here's your permanency rating. If the insurance company agrees with the rating, they'll issue a payment based on the percentage and the dollar amount assigned to that percentage in the statute. If they disagree with it, maybe they agree with part of it, and they'll issue a minimum percentage rating. So it varies from case to case, but it is, again, a creature of statute.
And that's kind of a perfect situation, I think. I think what happens sometimes is I'll talk with someone and they've been long at MMI and they clearly are entitled to some permanency and it just never got done.
Right.
For whatever reason. And so sometimes you can write to your doctor or ask your doctor, there's this thing called permanent partial disability. Do you think I have any? And then, depending on who the provider is.
Right. I think that was kind of the second part of the question is if you don't have a lawyer, you can just ask your doctor, what's the rating? Write it down. Sure. Let's see. Stephanie, here's a question. Person works in a wood manufacturing plant and got Lyme disease, thinks it came from work. Doesn't say how, but there's an assumption it came from work. How do you make that claim?
I have had a Lyme disease workers' comp claim. It's really a fact and legal conclusion for a judge to make because you can't prove. I mean, in most situations, you can't prove. Well, I was here when this bug bit me. I was doing this. What typically happens is someone develops Lyme disease, and in some situations, you can point at the time you spend in an environment that's otherwise full of situations where you might develop it. And I would think most insurers would deny that claim. You would need a really compelling case, I think. The
question is it just an ordinary disease of life? If let's say
Right.
they're a hunter
Right.
and they're out in the woods all the time, really the question is that increased risk of Lyme disease from work, or is it from your personal activities? And it does become that factual.
Yeah, and it goes towards the fact that we don't have to prove anything 100%. What we'd be doing is going before a judge and saying they work in a wood manufacturing and they have for forever and they've been working overtime and this is when the symptoms developed, and outside of that job they never went outside, and you'd have to lay out all the facts and the judge would have to make a decision there.
Yep.
Seems to me that's a tough fact pattern. Because
It really is.
It's a tough case, and the case that I had, you had some very good facts. I think it would be typically a very difficult case to prove.
Especially in this region. I
Yes.
think if you're living and working in a geographic region where Lyme disease is relatively prevalent, I think it's a much more difficult case to prove because what's the unique circumstances of your work environment that led to Lyme disease?
Yeah.
Right.
Yeah,
Go
I
ahead.
think the tick that bit me came off my dog in
Right.
the house. I mean,
Right.
Yeah.
Well, and Lyme disease too, separate and apart from where it came from, there's a lot of biases in the medical profession and elsewhere about the true consequences of it and how long it can last. How severe these symptoms can be and how disabling, and so that's frequently a factor too, is getting someone to understand what you're really going through.
Right.
Yeah, it's similar with like needle sticks for surgical employees. Yeah. Sean, why does it take so long, almost to the point of bankruptcy, to get a workers' compensation case resolved or benefits awarded? I guess this presumes when there's a denial.
Well, the short answer again is because the system is designed that way. Now, so long doesn't necessarily mean so terribly long. Once a piece of litigation is started, typically through a claim petition, there is a sequence of events in Minnesota. The first event is a settlement conference. And the settlement conference by statute is supposed to take place within 120 days or 150 days of the claim petition. Typically it's within those 5, maybe 6 months. And things happen between that as well, but that's the first event that's statutorily commanded to happen. If the case doesn't settle at a settlement conference, then typically within 90 days there is a trial. So now we're about 9 months out, and then the judge has 90 days to make a decision, so now we're a year out. In reality, well, we weren't all ready for the settlement conference because we needed this piece of medical evidence, or we needed this report, or you hadn't fully recovered from the surgery, so it delays the settlement conference. Sometimes the employee needs to gather up additional evidence. Sometimes the insurance company needs to gather up additional evidence. So the long and the short of it is litigation simply takes a good year to year and a half to conclude. And we all wish it was shorter. No one really likes that. There's really not a way to shortcut it that I'm aware of.
Well, what about requesting an expedited hearing?
You can request an expedited hearing, but only under very unusual circumstances. Sometimes the insurance company doesn't answer the claim petition right away. When they don't, you can skip the settlement conference and go right to trial. It's hard to tell a judge. I mean, you can ask for an expedited hearing because of what's called an affidavit of hardship, showing that you are really in a financial hardship situation, which again skips the settlement conference stage. But the employer and insurer are still given an opportunity to mount a defense by gathering up the evidence that they need. One of the things that they get is this doctor exam, and by law they get 120 days to do that. So
Right.
there's not a lot of super fast ways to move a work comp claim along.
Kathy, here's a question. I had to pay a few of my own medical bills from a work injury and was never reimbursed. Why not? How can we fix that?
Well, the question is, were the medical bills deemed to be related to the work injury or not? Is that a personal feeling it's related, or is it something that the employer and insurer recognize were related? If it was related, contact the insurance company, say, hey, these didn't get paid by you, see if they'll pay them voluntarily. And if not, there may be a part of a claim you could add them to get them paid as out-of-pocket costs.
And there is a separate medical request procedure. How
Correct.
does that work?
The medical request procedure we talked about earlier on a medical only claim with certain kinds of attorney's fees, but you file a form called a medical request, only involves medical benefits. And on the other hand, if that medical treatment is found perhaps related to the back but not reasonable and necessary, perhaps it's a 9 months of chiropractic treatment and the insurance company said, you're done with chiropractic care. Under the statute, we don't have to pay anymore. Maybe it's still related, arguably, to the work injury, but it's no longer needed to be compensated as part of the work injury. So there's different layers of questions involved.
You don't always need a lawyer to get bills paid too. You can call the Department of Labor and Industry, and they have fabulous people working there. And you know, you can call them and say, I have these bills, I never got paid. And sometimes the Department of Labor and Industry will call the insurer and say, are you going to pay these bills? And they'll call you back and say they're going to pay the bills, you know, or whatever. That's a good step to take before, you know, you start worrying about getting a lawyer.
Yeah, and you can look up Department of Labor and Industry, Minnesota, and get the phone number and
Yep.
stuff.
Yeah, and there's one right here in Duluth, and then the rest of the people are in St. Paul.
Stephanie, if I live in Minnesota but I work in North Dakota, get hurt in North Dakota, where and how do I bring a claim?
Hopefully in Minnesota. North Dakota has very difficult workers' comp laws, but the decision about where a workers' comp injury is venued is very fact-specific. I get all the fact-specific questions. It depends. But the factors that go into deciding that are, you know, where were you physically when you were hurt? Where are you usually when you're working? Where is your employer based?
Where were you hired?
Where were you hired originally? So it really kind of depends, but you should try to venue it in Minnesota versus
Yeah,
North Dakota.
there is that specific statute regarding employees who, North Dakota is a special circumstance.
Right.
Okay. Sean, if an employee leaves a job on a break, gets into a car accident, is that covered under workers' compensation?
Typically, no. The only reason that leaving the premises in a car would be work-related is if you were doing something for your employment while you're out. I was going to go to Target and buy a bunch of paper towels for the office. And my drive to Target, I was in a car accident, got hurt. Okay, now that's work-related. I was going out for lunch with my buddies, and I got in a car accident before I came back. That's not going to be covered.
Yeah, and there's exceptions to that all over the place.
There are some certain exceptions depending upon if you always need your vehicle, and if you're on call, things like
Isn't
that.
it-
But generally speaking,
He's
being
really
on a break
pecking
is
us.
not covered. Yeah.
We are down to about 1 minute. So Kathy, you get 30 seconds. Do insurance companies always do surveillance? How do they decide when to do that?
No. There we go.
Okay, we kind of suspect that they're always doing surveillance, but they only tell us when they think they have the dirt on our people.
No.
Really? Really? Okay.
Really.
Yeah, that's a follow-up question for cross-examination. Really? And sometimes you get it, well, no. Okay.
No.
Right. So what's the real truth?
No.
All right.
No, it's usually not worth pursuing. It's very expensive. It's unless you have a firm lead that really the employee's doing something they shouldn't be doing. It's not as if this is part of the typical claim handling procedure.
All right. Well, thanks very much, all of you. Thanks for the great questions. I'm sorry we didn't get to all of them. Good show. Thank you. That's all the time we have. Please join us next week when we answer your questions about drunk driving in the law. And I specifically want to thank our panelists again for this evening. And thank you for watching. I'm Jim Peterson. Good night.